and mediation, etc., along with not only being a good orator and hammering the point, not only in court, but besides the court. I would say he can create his own impact with his own style of speaking. Therefore, after the emergence of this commercial suits and the civil suits, these are the issues which keep on arising in the minds of anyone. Therefore, we thought and requested to a person who knows the inside out of all these aspects. Therefore, we decided to take the session on substantive and procedural law, commercial suits vis-a-vis the civil suit. Mr. Amarjit Singh Chandhiok, as I earlier said, a senior advocate, requires no introduction as such. He has been the president of the Delhi Bar Association, former additional Solicitor General, president-elect Bar Association of India, and president in Sol India and president in Madhyam. And when we say of Madhyam, Madhyam may be a different perspective, but I remember that when we went to way back in Dubai and Mauritius and way back the year 2019, I never knew that that interaction with him would become the Madhyam for all these relationships, which could cultivate, as they say, just like what they say in the Chinese, they say that the bamboo trees grow up. Maybe for good 5-10 years, they don't grow, but then they keep on growing. And similarly, the relationship has grown. Maybe for 5-10 years, it was just simmering within, but eventually it has translated for the knowledge sharing. And it's always a pleasure connecting with Mr. Chandhiok in respect of subjects of law and even otherwise. Without taking much time, being a weekend, I will say to Mr. Chandhiok to take things forward. Over to you, sir.
Thank you, Vikasji. Let me first of all thank you for giving me this opportunity to be amongst my family, my fraternity, and whatever you have spoken to me, the credit entirely goes to the fraternity. It doesn't go to me at all. It is their love, your affection, your looking at things and holding my hand and taking me like a child to the path that it has brought what has brought today. Thank you once again for giving me this opportunity. In fact, I was looking at what Vikas has bestowed on me today to say the distinction between ordinary civil suit and a commercial suit, both substantive and procedural. It brought to me my childhood as a entry into the law profession, when one saw that you don't need the statutory back of any statute, anything, to file a suit. Section 9 of the Code of Civil Procedure entitled you to file a suit for any wrong which in your view was a grievance or you were aggrieved of. We continued with this situation, though under the Punjab Courts Act, you will find a position of a commercial judge already incorporated into it. But we saw a change for the first time brought in by the Commercial Courts Act of 2016, which said, they described what is a commercial dispute. And to me, it takes almost every transaction into its fold, starting from a transaction of merchants, bankers, financiers, going up to Carriage of Goods Act, import exports, franchisee agreements, agreement relating to immovable property, but it said only used for trade and business. So the residential properties do not form part of the commercial dispute. Distribution of licensing agreements, management and consultancy agreements, joint venture, shareholders agreement, which otherwise were governed by the Companies Act even today, subscription and investment, mercantile agency, what almost everything, including insurance and contracts of agency, came to be known what we call in terms of the definitions of the Commercial Courts Act 2015 as commercial disputes. So we made a departure from the ordinary civil court to what we called a commercial court, and we've now brought into a concept of a commercial division and a commercial appellate division. So the honorable judges who are otherwise called trial courts or sub-judges or additional district judges or civil courts got a new nomenclature under the Act, which said you are now the commercial division as an honorable single court or the appeal court as an appellate court. Then it made the change with respect to the very filing of the action under the Commercial Courts Act. While we all know that if I have to file a suit with respect to an injunction, a plaintiff is entitled to bring his own valuation, unless, of course, on the face of it, it's arbitrary, where the court can look into it. We also saw when there was a negotiable instrument, we used to value our suit accordingly. When it was suit for possession, we used to value it in terms of your landlord-tenant, then the valuation is provided in a different yardstick. But when we brought Commercial Courts Act, it said of a specified value. So the Act, in fact, brings within it a valuation distinct from what we saw in ordinary civil suits. It has to be valued properly. And in terms of Section 21 of the Commercial Courts Act, this law overrides any other law for the time being in force. Therefore, if there's a conflict, for example, between the law in relation to Sale of Goods Act, the Commercial Courts Act would apply, not really the Sale of Goods Act. Though many a times the question has arisen that whether the property in the goods will pass in terms of the Sale of Goods Act, or would it pass in terms of the Commercial Courts Act? The answer is that the first act still governs, because there is no provision under the Commercial Courts Act as to how the property will get transferred in goods. Therefore, while the substantive law of Sale of Goods Act remains Sales of Goods Act, while Transfer of Property Act remains the primary act under which it is done. But if it comes to a immovable property relating to commercial user, then it says Commercial Courts Act will govern the same. The reason is twofold. First reason is, unlike CPC, which we found many times have been commented upon, that has been a source, though it was brought in 1908, we have brought some amendments to it, but we have not sufficiently discharged our duty in terms of what CPC is laid. And most of the time, the Supreme Court said, just this procedure is handmaid of justice, we can mold it in any manner we want. But the Commercial Courts Act brought for the first time a concept that the timelines are fixed today. A case management is fixed under the Commercial Courts Act. Therefore, how you will deal with a commercial court or a commercial dispute, which falls within Section 2 of the Commercial Court Act, is a substantive change even while filing a plaint. To give you an example, while Section 26 of the Code of Civil Procedure provides that we can file a suit provided with an affidavit verifying the contents of the plaint. That verification affidavit also came by an amendment to the CPC. But we've got another amendment by 2015 amendment, which said you will have to now file an affidavit apart from the first affidavit of a statement of truth in terms of Order 15A, which will show what statements made by you in the suit, in the plaint, are truthful. You have not suppressed something. Therefore, a format, statutory format came to be provided. Therefore, 26 itself made it mandatory in terms of the substantive law that I can't institute a commercial suit in a commercial division if I do not comply with both affidavits. So the first departure was made with respect to not procedure, but with respect to raising a commercial dispute. A question may well be asked to my own self, that do I have an option after 2015 Act? The answer is no, I can't. If it is a commercial dispute within the meaning of Section 2, then that suit will have to be a commercial suit in terms of the Commercial Courts Act, read with, as I said, Transfer of Property Act, Sale of Goods Act, Shipping Merchandise Act. All those things will come in, maybe under the Contract Act even with respect to the agreement that we have, under the Companies Act when it comes to shareholders. But the format and the evaluation will have to be done this. We made another departure in 2000, amendment to the Commercial Courts Act, where we introduced section 12 capital A. Unlike a suit, which I can immediately file in a case with respect to Commercial Codes Act, section 12A is brought in, which says I must have a pre-litigation mediation. Therefore, I can't institute a suit with respect to a case which falls within the meaning of the Commercial Codes Act unless I have exhausted the remedy of a pre-litigation. A question may well be asked that if supposing I'm seeking urgent relief and I need to look at that, there of course the court law made an exception that you may move the court. But now earlier, as I saw, we lawyers were just filing applications to saying I'm seeking an interim relief, my lord may entertain the suit, which we made a departure now. If you want to even seek urgent relief, you must take leave of the court in terms of section 12A, exempting the plaintiff from moving the court. But 12A does not bar the court to once again send the parties back to mediation if it so desires and if parties feel that it can resolve. Therefore, first substantive change is while all other civil suits, I don't need to take leave of the court. I don't need to go to pre-litigation mediation. In a commercial suit, I must comply with 12A unless, as I said, an exception is made that you are seeking any substantive interim order to protect the subject matter of the suit. And as now Delhi takes the view that you will have to take an exemption from the court if you are not wanting to comply with section 12A. Because the word used in 12A are till you exhaust this position, you can't knock the door of the court. The purpose is very laudable because we are seeing every day the briefs and the court dockets are going up. We are not able to meet the demands of the dispute and conflicts. Conflicts is inherent in everywhere, whether in your commercial world, especially, and because time is very, very important. And there's a value for time in one way, and you must not spend judicial time on frivolous litigation. So, and also give parties an opportunity to meet and resolve itself by the process of mediation, which is a structured process now. In fact, a bill on mediation has already been presented to the parliament. It has gone to the Joint Parliamentary Committee, and we hope that probably in the next coming sessions of the parliament, probably we'll have the mediation law in place. But having said that, for the purpose of today, I can only say 12A is a substantive change in law from a normal civil suit. And that's the first major change that we brought about. We also brought about, as I said, a change in the valuation. Therefore, you have to have a specified value in terms of my suit will have to be done that. This third part is equally important, is that I have now to state everything in precise form. Unfortunately, the experience now today shows that what we have started looking at in plaints and in the writ petitions also, that we say in Mahesh versus Galaxy A31 or so, the Supreme Court said this, or Punjab Haryana High Court said this, or Delhi High Court does this, and we start quoting the judgments. That is no pleadings. Even if I was to take a distinction between a plaint in a commercial suit and a plaint in an ordinary civil suit, or even a writ petition, my request is that we all must consider that we stop quoting law, especially the judgments from the Supreme Court. Because the first principle of the interpretation of any judgment is that you are looking at that judgment in the context in which it is delivered, not in the out of the context. It may not apply to your facts at all. We start reading one sentence and we quote that sentence in our plaint that way. So therefore, the first request is that whether it's a civil court or a commercial court especially, I don't need to look at what the law of the land is. I need to plead all facts. Therefore, in terms of Order 4 now, the second departure comes in, that my complaint in a commercial suit must comply with Order 6 and Order 7. And those two, then only plaint travels into a suit in terms of Order 5. The Code of Civil Procedure by this amendment of 2015, 2000 Commercial Codes Act, has amended the CPC also, and therefore new provisions on procedure will I come to a little later with respect to the same. So the question for your consideration would be, when a matter comes before you, to check up whether that dispute falls within Section 2 of the Commercial Codes Act. then you will have to invoke the jurisdiction of the commercial court or the commercial division as we call it, and then also ensure that the amended provision of CPC, which are now amended by virtue of the Commercial Courts Act, is adhered to. While the statutory provision under which the transaction is governed may remain the same, but everything else, how you can invoke the jurisdiction, what is that you have to comply with the condition precedent, as I said, section 12A, will have to be complied by us, unlike a civil suit. The third part is that the documents, if not filed along with the plaint, will not be allowed to be taken. In fact, it's easier for me to say that the Commercial Courts Act equally applies to arbitration proceedings by virtue of the provision of the Commercial Courts Act. So it's not a case that Arbitration and Conciliation Act 1996 governs it, but now after coming into force of 2015 Act, the arbitration is also governed by the Commercial Courts Act. So both acts have to go side by side in order for a person to invoke, whether it wants to invoke section 9, so where as court's jurisdiction is concerned, wants to invoke section 11 for the appointment of arbitrator, or it even wants to invoke the jurisdiction with respect to asking court's assistance, with respect to anything that we are looking at with respect to witnesses, etc. Consequently, wherever the jurisdiction of the court is involved, the Commercial Courts Act will have to be read along with the Arbitration and Conciliation Act. A question has arisen, and I must bring it home, that submission before you, that in section 8 of the Arbitration and Conciliation Act, the amendment, post-amendment says that wherever a suit is filed, in fact, the word used is wider, wherever an action is brought, which is the subject matter of an arbitration agreement, then the defendant is entitled to file an application under section 8 to request the learned judge to pass an order referring the parties to arbitration. So two distinctions have been brought in now, and that distinction is disputes are of no relevancy. It is the arbitration agreement which is relevant. In terms of section 8 and 5 of the Arbitration Act, today, the arbitration agreement is there between the parties unless the court comes to the conclusion, and here again a distinction has been brought about by the law, that court becomes a judicial authority. And that judicial authority then exercises jurisdiction, not with respect to either under the Commercial Courts Act or under the Transfer of Property Act or of Sale of Goods Act. It actually exercises jurisdiction under the Arbitration and Conciliation Act 1996, and therefore the jurisdiction gets restricted by section 5. But if there is a cross-border dispute, though the agreement with respect to New York Convention brings in section 45 of the Arbitration and Conciliation Act, but the jurisdiction of that very judicial authority gets extended, while in section 8, it has only to look at whether the arbitration agreement is prima facie valid or not. In section 45, it looks at something totally different. Apart from validity of the agreement, it also looked at it, whether it's operative, whether it's null and void, and also looks at it whether there's a subsequent event which entitles or to defendant to urge that it has been abandoned. So these are distinctions in commercial situations when I travel from domestic law to the international law in respect to arbitration. But the Commercial Courts Act makes this distinction because the dispute is commercial. Most of the arbitrations, if I go back, arbitrations never used to be with respect to specific performance of an agreement to sell, for example. But the law underwent a change. Today, the Specific Relief Act has been amended to, therefore, the arbitral tribunal will be within its jurisdiction, read with the Commercial Courts Act to exercise jurisdiction with respect to a commercial dispute, even arbitration. Earlier, the argument raised in the court was that a Specific Relief Act uses the expression court, and court can't be an arbitral tribunal. There's a distinction in law, but that distinction by the courts have now been wiped out totally to say an arbitral tribunal can rule and grant a decree of specific performance. A question may arise in relation to a commercial dispute. If there be a commercial dispute in substantive provisions of Commercial Courts Act, and the person invokes, for example, Section 7 or 8 or 9 of the Insolvency Act, there also the court has looked into to say that since it's a contractual dispute, commercial in nature, not really a case of CIRP or what we call it restructuring, which is the condition now first after the insolvency law of 2016 has been brought in to say that parties will go to whatever forum they have chosen, namely the arbitration, or may go and see elsewhere a commercial suit within the commercial division. So the question has to be judged when we get a brief to see, is it a commercial dispute? Is there an arbitration agreement? And if they are both consistent, then we must invoke the same in terms thereof. So all these enactments have been further in terms amended by the Commercial Courts Act, and new dimensions have been given, and the purpose is twofold. A commercial dispute must be resolved at its earliest, whether by adjudication or, as I said, in terms of Section 12A, by a mediation process. B, the new change that has brought in the substantive law is that even if I as a plaintiff may succeed in the suit, but if I find, the court finds ultimately that something has gone wrong in my end and I was not looking at the proposal that the defendant had given me, then the cost of the defendant, notwithstanding the decrees passed in my favor, in terms of amended Section 35 of the Commercial Courts Act, will still be borne by the plaintiff of the defendant. So these are new changes of substantive law which has come in. New jurisdictions have been conferred on the court to look at it. How do you do it? To give you another example, we never had a system where we looked at case management. Now, case management is provided now by the Commercial Courts Act, and after the pleadings are complete, the matter goes. Normally, we all know in normal civil suit we say matter is listed before the court for framing of issues, but that situation has now undergone a change in terms of commercial disputes by a substantive provision under the Commercial Courts Act, which says that you shall have a case management hearing where the honorable judge, after hearing the parties, would look at say as to what issues come in, where should be the statement to be filed, what all should be done, and a case management hearing takes place to see if timelines are framed so that those timelines can be abided and gone into. It is important for me to mention today, because of the pandemic, we saw the Supreme Court has time and again said that time from March 2020 will be, in the initially state, they said, will be extended. Then the Supreme Court realized its own mistake and said, no. Of course, the extension has to be within the meaning of law. Law doesn't provide that extension. So they have now, the subsequent orders, if you see, of the Honorable Supreme Court, says these periods of pandemic shall be excluded for the purpose of determining limitation. So that period, in terms of the interpretation of Section 14 of the Limitation Act, gets extended now. No, gets excluded, not extended, as I said earlier. But the question today remains is that the Supreme Court itself saw that, notwithstanding those general orders, and I need to press it very formally before all of you, please look at whether it was Order 8 Rule 1 earlier or whether it's Order 8 Rule 1 post the amendment that we have brought in by Commercial Courts Act. The first Order 8 Rule 1 said a defendant will file his written statement within 30 days of the date of service. The Commercial Courts Act said you will file it in 30 days, but then ousted the jurisdiction of the court to even extend time or exclude time after 120 days. So the question may well arise that whether, if the defendant had not suffered any consequences, any ill effects of the COVID, and was regularly precipitating the dispute or was precipitating the proceedings in courts, then would he be entitled to this general order passed by this Honorable Supreme Court saying this time will be excluded? Is a question pending determination today before the High Courts, and I'm sure one day we'll get clarity on this, because my personal view would be, if the defendant is not able to show, or for that matter, even the plaintiff is not able to show that I could not file my suit within time because of some COVID exigencies that have happened in the plaintiff's own life, the court will have no jurisdiction, to my mind, to exclude that period, even for the purpose of determining the limitation, even for respect to filing a written statement, with especially in relation to commercial suits, if 120 days have passed. So the statute has not been amended. That time has to be excluded only from facts of each case. Whether a particular case, I have made out a case for exclusion of time or not, is a question of fact in the facts and circumstances of each case. Coming back to the situation that if there is a franchisee agreement and the agreement is determinable by flux of time or by termination, and if that termination has taken place, can you determine that? We used to file normally a suit for injunction restraining the defendant to do so. But now we'll have to look at it from a different point of view, both with respect to Commercial Courts Act and the Specific Relief Act, as to when can the court grant that injunction in respect of an agreement which is determinable. There's no change so far as substantive law is concerned. To my mind, an agreement which can be terminated or is determinable by its very nature can't be a subject matter of specific performance. Therefore, we need to look at these aspects of the matter before we proceed further. The statement of truth, which is statutorily now provided under the Commercial Courts Act, is extremely important. Earlier, our experience shows that many times we never used to produce documents, especially those documents which were going against the plaintiff or the defendant, as the case may be. The departure now made is that you will disclose that document also, even if the document goes against you. Therefore, there is a departure in a substantive law. It's nothing to do with procedural law as such. Procedure is that I have to file an affidavit, but the disclosure of that document becomes important. And for a defendant and for the plaintiff both, a stringent amendment has been brought in that I can't, normally speaking, what we used to do, signatures admitted, contents denied in a document. Today, the law under the Commercial Courts Act puts an obligation on the plaintiff and the defendant, not only to say that the document is admitted or denied. If you're denying a document, you will have to give reasons for the same. You have to deal with the contents of the same in the admission denial of documents. In the case management, the court would probably ask both parties to file their affidavit by way of evidence. Of course, a lot has been said, and I think a debate is rightly being held that we need to look at days when we go back to trials in the open courts. These local commissioner trials for our youngsters especially, we must abandon them, because if you see the experience that we used to have, a trial would begin in the High Court, in Delhi High Court, for example. We would end up with the judgment in the court. There was no chutti, no adjournment, except of course an exigency like that or something in a different matter. Therefore, we need to bring back that, because there's no trial, even in criminal trial, I find there's hardly any trial today, trial lawyers are going through. We need to exercise that power. We need to teach our youngsters what are the means of trial, why the trial is necessary. And for a judge to appreciate it, because judge says, I've seen the demeanor of the witness, the cross-examination and the examination chief is in my presence. Consequently, I find no reason why I should not look at it. Therefore, time has come that we must, it's actually started misusing, especially in the civil proceedings. We start filing an affidavit. Now see this departure that the court made with respect to substantive law. Normally speaking, if I remember my experience as a president of the bar, Justice Pradeep Nandajok was then retired as the Chief Justice Rajasthan, we all know. His Lordship was sitting on the original side. I was sent for to say, please call him. And he gave a file to me in the court and say, can you please read this affidavit by way of evidence? So with all humility at my command, the learned author of that affidavit had done nothing but copied the plaint again by cut and paste, including the cause of action, including the prayer. So I said, Lord, this is no evidence. So the departure that the Commercial Courts Act now says, each fact, you will have to deal with it. You will have to provide for it. The verification is different than what in the ordinary suit is there. Normally speaking, a verification has been said to be a curable defect. I'm not saying even in the Commercial Courts Act, it will not be possible to cure the defect. But the stringent measures have come in so that a false and vexatious litigation can be stopped, and to use the words of Justice Krishna Iyer, nipped in the bud before it takes the judicial time of the court. Because time of the courts is important, keeping in view the dockets that we are having today in the courts. Therefore, we need to look at it. An affidavit must prove. And today I found, in fact, this afternoon, an affidavit was read by me, which affidavit only said, I am the plaintiff. I am the power of attorney holder of Mr. So-and-so. And the said power of attorney is Exhibit P1. Nobody has proved that document. So the law, in terms of the amendment, especially in relation to commercial disputes, tells us, compels us, obligates us that we will have to prove each document. And proof of document is no distinct from a civil suit and a commercial suit. Of course, there are stringent provisions with respect to the same. We must also look at it from the point of view that if the court finds at the time when it's doing case management that you have no issues really substantive, the parties are not adversarial on each other, then apart from using, as I said, the power of its mediation, even post Section 12A, it is entitled to pass a decree, maybe on some issues or on all issues. But because if the court finds that actually speaking, no issues of fact arise which relate to recording of evidence, because normally the rule is access to justice, we all feel, means that you must hear us with parties, then you must hear us on arguments, then you must also do something with respect to trial. So unless trial takes place, there's no opportunity really speaking given. But the statute is amended, which now puts an obligation on the honorable judge that without even evidence, if in the case management itself, it finds that it needs to decree the suit of the plaintiff or dismiss the suit of the plaintiff, it shall proceed to go ahead with the same. Let me give you a very small example of the fact. A commercial immovable property, along with some of the properties that the parties had, were owned by two brothers. A brother filed a suit in terms of now the Commercial Courts Act, claiming partition of those immovable properties, and by virtue of the fact that immovable property to be used for trade and business in terms of the Section 2 subclause 8 would be a commercial dispute, obviously filed a commercial suit. The defendant came up and said, this suit can't be maintained because we had, by an oral partition between us, distributed these commercial properties, and I am in possession of ABC in terms of that oral settlement, and he is in possession of the other. On being confronted by the honorable judge as to what he has to say, the plaintiff withdrew the suit, thinking that probably it will work. But after a few months, we saw the plaintiff filing a suit once again to say that probably the defendant had made a statement, but that statement was not correct. The court now at the stage of case management looked at it, and on a principle of Order 23, Rule 1, dismissed that suit, saying that you having not taken leave from me in the first suit, and I must bring to all my friends' notice, this will equally apply to a civil suit, whether it's commercial or it's not commercial. Because if I withdraw a suit, I would not be entitled to bring in the suit unless I brought a leave of the court. And an interesting question, which I thought I may bring to your notice, has come in now and being pending now consideration for the court. And this is this. In Delhi, as we all know, in Punjab also, probate is not compulsory. Therefore, a suit was filed with respect to the estate of a deceased. The suit was dismissed. The matter is in appeal. In the meanwhile, the other side now comes up and files this suit, substantive in nature, based on a will of the deceased. The question that has arisen is, if will was not pleaded in the first suit, can you now bring will into it? That's a matter of pending consideration. I do not wish to comment on it, but these are questions that are arisen. And now with the situation as we find in the commercial courts and in substantive law. Unlike the Rent Control Act, where we have a lot of litigation because the tenant is protected, because most rent controls are protecting the old tenants, but with the new tenancies coming in, with the so many litigation coming with respect to landlord and tenant, especially in relation to commercial disputes, we will find that the commercial courts act governors, and the court will be entitled at the time of case management to pass a decree if the defendant has no defense or nothing. Normally, we used to say the tenancy was extended. No tenancy can be created without a written document in terms of Section 107 of the Transfer Property Act. And if there's not a document which is registered, no extension can even be there. There's a misnomer in my humble view that 11 months lease does not require registration. To me, it says a document of lease must be in writing. And the moment it is in writing, it requires registration and stamp, both. So one will have to look at all these aspects, probably with the new change of law, new change of substantive provisions, all this will have to be looked at by us to see how do we bring these changes into it. But we must note at the same time that the changes have been brought in substantive and procedure. For example, I don't think in most of these civil proceedings, we have ever utilized discovery of documents. But in the Commercial Courts Act, it specifically provides and empowers the court to call a party to make a statement in terms of Order 10.2. And the conflict that is coming in today is earlier a derivative action. For example, if I'm a minority shareholder less than 10% of the value of the shares, I was not entitled to go to company court in terms of the erstwhile 1956 Act. But 241 of the new Act, the new provision of the Companies Act now empowers the NCLT to exempt it from filing, to exempt it even if the shareholding is less, even the numerical numbers may work. So we'll have to judge the new provisions of the commercial courts, a new provision of substantive provisions of law in relation to any action that we propose to take. Because if the action is not in terms thereof, we will not be entitled to maintain an action with respect to the same. The question that most of us find it difficult is our admission, denial of documents and trial, which to my mind, if you just look at the new provisions of the amendment of the substantive law in relation to Commercial Courts Act, you will find that in the case management, the court passes an order, which if the admission denial is not in terms thereof, the court will reject it. If the verification of your written statement or your plaint is not in terms, strictly in terms of that, we find most of the time what we say in verification, verified this day at Chandigarh, that the contents of the above affidavit are true to my knowledge and belief. In fact, I remember 1968 Punjab itself said that such affidavits have no legal sanctity. And after coming into force the substantive provision of the Commercial Courts Act, such affidavits in any case do not comply with law. And therefore, care has to be taken by us to see what portion of the plaint, because ultimately it's the responsibility being cast on the plaintiff or the defendant, whosoever it is, because both the plaintiff and defendant have to file a statement of truth. And that statement of truth is to be judged in relation to every paragraph of the plaint and the fact. And if there is something to be disclosed on basis of information, then I must say on verification, whose information am I saying so? This brings to me another aspect that I thought within the time frame that I have, I must touch it. While under the ordinary civil suit, normally we say it is denied that the name of Mr. Amarjit Singh Chandhiok is his son of Mr. late Mr. Substantive Singh. The defendant even says it is wrong and denied. The law has been amended now in terms of its procedural aspect to say that if the defendant in a commercial suit wants to deny this, he will give me reasons for it. Now, in this case, what reason can you probably give unless you know that the name has been actually, I am not actually adopted by somebody, or that I was not born from the wedlock of my father, late Mr. Substantive Singh. Then it's a different matter, but therefore I must give reasons. So the procedural law is amended to say a defendant will not only merely say, or paragraph 1 of the plaint is wrong and is denied. it must give reasons for its denial. It must specify what is according to this the truth. Therefore, there is a departure being made in the procedure, even with respect to denial. As I said, even in relation to documents, admission denial, both plaintiff and defendant will have to give reasons. Therefore, even in pleadings, it will have to give reasons as to what is it saying, what does it want to say, and what is not saying. To most of the time, we just say it's wrong and deny it, and then say, and excuse my saying so, I see that almost every day. The defendant says the plaintiff is put to strict proof thereof. And it reminds me of an honorable judge who was a very eminent lawyer, and I probably in 74, 75 had a 100 lawyers law firm at main Kasturba Gandhi Marg, Parliament Street. And he was the honorable judge. And a question that came before his lordship was that, what is that this denial that you are doing? Merely in terms of even Order 8 Rule 5 as it exists in civil court or the ordinary civil suit, unlike a commercial court, mere denial is not sufficient. Putting somebody to strict proof, in fact, amounts to admission. And consequently, the court will be within its jurisdiction to pass an order. Many people urge that in relation to, for example, when you're suing a person for rendition of accounts in any commercial matter, should the court not first pass a preliminary decree and then proceed to pass a final decree? To my mind, if the court finds that there is no plausible dispute being raised by the defendant to the claim of the plaintiff, or a counterclaimant by the defendant for the plaintiff, the court will be entitled to pass a final decree, asking a plaintiff or the defendant, as the case may be, to look at it and pass a final decree asking him to rendition of accounts. Therefore, a court always had jurisdiction, to my mind, unlike bringing this change, to pass a final decree, of course, in the circumstances of the case, but with giving the jurisdiction now in terms of Order 15, it has to look at that. An interesting question may now arise with changing of times for us, that if the dispute relates to, and this is in relation to testamentary jurisdiction, I thought I must bring it home to my August gathering, that if on the date when I am executing a will, for example, the estate never belonged to me, and even on the date of my death, it never belonged to me, could I be a person who would exercise right under the Indian Succession Act to do so? Another interesting question is pending consideration is that if my wife or my daughter, who has become co-partner with me in the Hindu undivided family, is their right absolute, and therefore would be governed by that their estate would go back to the father? Because earlier, if you remember, by a survivorship, we used to take that situation and say the share of the other co-partners becomes more, and it doesn't go by succession. But to my mind, the law has undergone change. Today, a woman's right is absolute in the property, and the succession situation, even whether it's a male or female, does not arise. In fact, the doctrine of relating back will apply so far as females are concerned, because the statute today provides, post-amendment of 2005, that her right to property is absolute, and it relates back to the date of her birth. So this controversy, fortunately, has now been put to rest by the Supreme Court, because earlier view was different. It said if the father is dead on that day, then the claim made by the daughter is of no consequence. The Supreme Court said no. The argument or the right emerges on the date of the date when she's born. It has nothing to do with the date of the death of the father. So there's no notional partition comes in. Now, these are changes that we see over a period of time. And these changes, to my mind, are extremely important when we are determining what we should invoke as lawyers, what should be the contents of our plaint, whether I am doing a civil suit or I'm doing a commercial suit. And we must look at the transactions, because many times we find that commercial transactions are being overlooked by us when we are filing our plaint. We must look at the amended provisions of the Code of Civil Procedure. The Specific Relief Act has been amended. The Transfer of Property Act has been amended. In fact, many of you who would have done this landlord-tenant relationship, we used to urge many times in courts, I think time and again, this question used to arise, that this notice is fine of termination of tenancy, but does not terminate the tenancy in terms of the agreement and in terms of the agreement between the parties, that my tenancy will terminate, or will every monthly tenancy will come to an end, say on 25th of March 2022. The amendment was brought into Transfer of Property Act to say this defect in notice will not entitle a defendant to challenge the notice. Therefore, all that is a step in the direction to see how do I curtail litigation, how do I contain conflict. And that is why I think when Mr. Vikas drew your attention that we have looked at Madhyam in this way, we are looking at Madhyam and we are looking at this conflict resolution only to ensure how do we bring more harmony between the people. In fact, I am very proud to tell you people, we have been able to resolve commercial disputes between the families by total Indian mediation style, by my touching the feet of the elder to say, if I could touch, the younger stands up to say, if Mr. Chandhiok, you can do it, I can also do it. And he touches the feet and the matter gets resolved. So we have this, our own traditions. We have traditions of this bar. We have traditions of our families. And most of the businesses in this country, more major businesses of this country, till recently are all run by families, whether it is Birlas or Ambanis or Antanis, or for that matter, Tatas. Everything is coming in the family. So please ensure, even as lawyers, if you can restore the relationship between the parties, attempt to do so, because that is the duty that we need to look at. Law has bestowed on us. We are not lawyers only for the saying that we are advocates under the Advocates Act. We are actually officers of the court. And if we are officers of the court, then it's abundant obligation cast on us to ensure if we can bring parties together to resolve the issue. This helps us in many ways. First, the cost of the parties. And I remember when 2006, when we started this process of mediation, many of my friends thought, including my own self, we thought probably it will be a setback to our practice. But we found that does not, it actually adds to your practice. And I always feel that when God bestowed this honor on me or you to come on this earth, that along with this passport of life that he gave me, till what date I have to be alive, he also gave me the visa as to what am I going to make in the life. Though, of course, the changes definitely come. My karam do make a difference. I am not disputing that part. That is why I think we still have our faith in our gurdwaras, our mandirs, masjids, and churches. But having said that to you, I still feel we owe a duty to the society as officers of the court to assist the court in bringing the parties back to their relationship, whether it's commercial or non-commercial. Because today, if the statistics with me are correct, I find at least 29% litigation today in matrimonial courts alone is cross-border, where children are being treated as chattels, and we are not looking at the welfare of children. Therefore, we as officers need to look at these situations to see how do we remove these conflicts in the society. If we remove these conflicts in the society, I can assure you, law will do much more, play a much better role in the lives of people than what we are playing today. In fact, two of youngsters who are interns with my Chief Justice were actually IT experts and then went to law. They're still in law school. And they thought that before they went to law school, they used to feel, no, lawyers can't be trusted. Now that they came into it and they saw what lawyers play a role in harmonizing society, how do they get access to justice, how they are able to do it. They are today looking forward to a day when they will become lawyers. So my suggestion is that please consider the distinction of substantive law between commercial disputes and civil disputes, between procedure adopted by the Commercial Courts Act and the ordinary procedure of the Code of Civil Procedure. And let us all resolve that if we are not able to get the right path, we should go to somebody else who can help us out to do so. But let's not commit mistakes with respect to the substantive or the procedural law and raise more conflicts in courts. They were already running quite high in our dockets. Let us do something to resolve them. And that's only possible when efforts like done by Mr. Vikas Chitrat, that we talk to each other, we have a communication. I think the communication is the best solution today. We need to communicate each other, whether we do it through communication or we do it personally, where we should resolve, iron out all our differences, iron out all the doubts that we have with respect to this law so that we can take that forward. I'm only leaving myself 10-15 minutes, subject to what Mr. Vikas has to say. If anybody has to ask any questions from me, I'm here to answer.
So how rightly you have put it across and hammered the point that the access to justice is very important to prevent the excess of justice to someone, and how the Madhyam and mediation have played a pivotal role in changing the mindsets and dynamics of law, coupled with the fact that you have also shared your insights in a bird's eye view. With that, one can always say that one will always learn in this short grasp. It's a encyclopedia and where one can learn. Meanwhile, I can take, since you have taken everything in the right perspective, there's one question from Advocate Satyadev on YouTube. It says, when is the affidavit in chief to be filed in the commercial suit?
Well, that's what I said, that a case management, the Honorable Judge has a meeting. In the meeting, the Honorable Judge, unlike you see in the civil suit, we normally do plaintiff first files an affidavit by way of evidence. His evidence is recorded and then defendant comes. Under the Commercial Courts Act, the court is 99.9% going to say both parties will simultaneously file their affidavits by way of evidence. So the stage comes when the court is looking at is whether there are issues. If we frame some issues, then we'll allow both the parties to file their evidence. But it will be only at the stage when it is putting that timelines are granted at the case management hearing, where the court says, I have now framed issues, you may file your affidavits within 4 weeks or 6 weeks, as the case may be, depending upon what they have to do. Unlike a situation where something, if that's why I said, if I don't have a document in my power and possession, I only have a copy and the original with Mr. Vikas, then I'll have to show to the court right there when I'm making that averment in my document, saying this document is in the custody of Mr. Vikas Chitrat. Therefore, the court will be entitled to call upon Mr. Vikas to file the original. If there's a dispute with respect to the contents are not in dispute, then obviously you don't need the original. And that's why the departure has today come. We have started looking at documents shown and returned. Take, for example, a sale deed. Normally, we say original document must be filed, but a document of sale I may require in so many other phases. So the court says, you please show that document, show the original to the other side. Unless there's a dispute as to the execution or the registration of document, that's a different matter. Otherwise, you should be able to do that. Now, if there's an agreement between the parties, which is franchise agreement, an agreement between the parties is joint venture agreement. The joint venture agreement, even if there's a copy on record, I'll be entitled to admit and deny the same. I can't say it's a photocopy, I'm not going to do so. Therefore, change has come in today. We must look at that change, look at positivity to see how do the purpose is how to accelerate the disposal of the matters rather than delaying it on one technical ground or the other.
This is by Astha Khanna. Thank you for this elaborate discussion. But could you please throw some light on Rule 8 subclause C of Order 15A? What exactly does allow the suit mean? Does it mean the judgment forthwith, or how about it?
Yes, yes. Please let me read with you that Orders 15 rule that. Can you, would it be possible to share it on the screen, brother?
So I will ask Astha if it can be, or I can just read that.
Yeah, I think so that everybody understands what we are talking about.
So meanwhile, the question by Muralidharan is, can the civil suit be transferred? Once the civil suit is transferred to the commercial court, Should it go to a pre-litigation mediation, or what is the position in that case?
Yeah, the question is this, Murugan, that is not a case that the pre-litigation really speaking. A lot of us feel that after we have gone to the court and 12A has, let's say we have met on 12A in a pre-litigation mediation, but we have not been successful, does not bar the court. Section 89 of the Civil Procedure Code still entitles. In fact, if you see Section 30 of the Arbitration Act, the arbitrator can take aid of mediator to see if we can resolve the issue. So the jurisdiction of the court, even if it's transferred from an ordinary court to a commercial court, does not take away its jurisdiction or the parties to say we will make an attempt to see if mediation can work. There's no bar. The court can do so. Please look at Order 15 Rule A. Let me start with that to give a summary to that. The court shall hold the first case management hearing not later than 4 weeks from the date of filing of the affidavit of admission to live documents by all parties to the suit. So a timeline has been given right in the beginning of 15A. Orders be passed in the case management hearing, and then A, B, C, D, E, etc. gives us everything what will be done. Let me straight away go to subsection 8 that my learned friend has got. Consequences of non-compliance with orders. If any party fails to comply with the order of the court passed in a case management hearing, the court shall have the power to condone such non-compliance. So the first answer is to your question, if I file for condemnation and give some good reason, the court is entitled to grant me a hearing, grant me condemnation of delay. So it's not a case, maybe subject to cost, which normally even happens in a civil suit. Foreclose the non-compliant parties' right to file affidavits, conduct cross-examination, file written submissions, address oral argument, make. Now it depends upon what kind of default are you committing. If I have been totally non-compliant of the orders of the court, unless I have some sufficient cause to show to the honorable judge, he'll be entitled to say the plaintiff's evidence is on record, or the defendant has filed his affidavit. That's why I said under the case management, both parties will be entitled to, the court will pass an order asking both of us to file it. Now, supposing the defendant has filed it, your right of cross-examination will be curtailed. It could be one of them, not everything. Then dismiss the plaint or allow the suit where such non-compliance is willful, repeated, and imposition cost is not adequate. Therefore, the mandate of the statute in terms of 8C is that you have been given opportunity. That's the fundamental principle of compliance with principles of natural justice apart from statutory provision. And you have sufficient cause to say why you could not do so. And there's a non-compliance is willful. Take the word from the Contempt of Courts Act. It also uses you are in contempt, willful contempt of the court order. So the same is willful. Not only willful, there's a comma after that. Then this word is repeated. And imposition of cost is not adequate to ensure compliance. So court finds that even if I were to burden the other side, burden you with cost to compensate the other side, it will not be ensure compliance by you. The court will be entitled to dismiss the suit. And that's why I said section 35 has been amended now, where notwithstanding that I have succeeded in my claim in my suit, if I have found my conduct has been bad, the court may impose the cost of the defendant on the plaintiff, notwithstanding that I have succeeded in the suit. So these are the changes that the statutory provisions have been brought about, which is substantial in nature and not procedural. The jurisdiction is vested in court to pass an order. Therefore, 8 won't be a mechanical order passed by the court. Court has to look at it. It's a non-compliance is willful. A, B, it is repeated. And if I was to even award costs, I will not get the compliance thereof. The court will be entitled to dismiss the suit or decree the suit, either case.
The last question, Mr. Manoj asks, can penalty of encroachment of setback of buildings fall under the Commercial Code Act?
No. That's actually governed by encroachment is a different subject matter. Or if you are saying even if you have covered an area which is a setback, is governed by municipal laws, whether it's a Punjab Municipal Act, it's a Delhi Municipal Corporation Act, NDMC Act. Therefore, that won't be a commercial in nature, even if the property is user for only trade and business, because that is the agreement in relation to a transfer of property. Therefore, the question was, if I have agreed to transfer a commercial property meant only for trade and business, that agreement falls within the meaning of section 2. The word used is totally different. Agreements relating to immovable property used exclusively in trade and commerce. And I must add for all of you that there is an explanation. It doesn't cease to be a commercial dispute. Supposing a dispute is with respect to a partnership firm, it may be a commercial dispute, and under that some property has to come to me on resolution. Doesn't mean it ceases to be a commercial dispute. It will still remain commercial dispute. However, the point that you have raised will be strictly governed by the municipal laws, where the tribunals are constituted. That's a total different hierarchy. It has nothing to do with civil suit. Unless you bring a civil suit to show there's a non-compliance of the statutory provisions of the Municipal Corporation Act or the Punjab Municipal Act, then only a civil suit lies.
Yes, sir. So we have taken the questions, and how rightly you have said and reminded that nothing is permanent except the change, and as they say that everything keeps on changing for the betterment. So thank you, sir, for sharing your insights, and people will be deeply enriched. Thank you, everyone. Stay safe. And on Monday, we will be having the session by Mr. Professor Venkatchalaya Hegde, Chairman, Center for Studies in Diplomacy, International Law and Economic Schools of International Studies from Jawaharlal Nehru University, New Delhi, along with Mr. Subramaniam from CMR University. Do stay connected with us on Monday. Thank you, everyone. Stay safe, stay blessed. Thank you.
Thank you, Ji. Thank you. Great weekend. Bye-bye.
Thank you.